And I'll just give you the punchline right off the bat. You don't get to make that decision. Whether it's a joint venture or a syndication, it is what it is. Tom Wheelwright always likes to say, if you want to change your tax, you've got to change your facts. Same thing with a joint venture. Whether you call it a joint venture, whether you call it a securities offering, whether you call it whatever you want, the SEC is not going to care what you call it. They're going to look straight through, just like a lot of other things we've talked about. The challenge is we get calls all the time and say, look, I'm looking to raise some money, but it's a small amount of money, or it's a small amount of people, or they're my buddies or what have you. And so they say something along the lines, well, I think I'm going to do this one as a joint venture because I don't think it's worth doing it as a syndication, or I think I want to do it as a joint venture because ABC. You don't get to make that decision. The facts are what the facts are. And so the only way to really make it a true joint venture, if you're raising capital, is to actually change the facts of your scenario. All right, well, welcome back to episode 41 of the Real Estate Syndicator Live. And if you're wondering whether you've done joint ventures illegally, you've come to the right place. This is becoming more and more of an issue. This is why I wanted to kind of dedicate a deep dive on this question of whether my raising capital efforts are a joint venture, or is it a syndication, or when do I use a joint venture, or when do I use a syndication? And I'll just give you the punchline right off the bat. You don't get to make that decision. Whether it's a joint venture or a syndication, it is what it is, right? Tom Wheelwright always likes to say, if you want to change your tax, you've got to change your facts. Same thing with a joint venture. Whether you call it a joint venture, whether you call it a securities offering, whether you call it whatever you want, the SEC is not going to care what you call it. They're going to look straight through, just like a lot of other things we've talked about. They want to know whether there's somebody on the team that's generating the returns of your investment. Because if you guys recall from all the other lives we've done, the definition of a security, my layman's definition is always, anytime you take money from passive investors where the returns are generated by your efforts, you're dealing in a security, you're selling securities. So the flip side of that would be not a security, meaning if the returns are generated by everyone's efforts, everybody is actively involved, then you can claim that it's a joint venture. The challenge is, like I mentioned before, we get calls all the time and say, look, I'm looking to raise some money, but it's a small amount of money, or it's a small amount of people, or they're my buddies or what have you. And so they say something along the lines, well, I think I'm going to do this one as a joint venture because I don't think it's worth doing it as a syndication, or I think I want to do it as a joint venture because ABC. You don't get to make that decision. The facts are what the facts are. And so the only way to really make it a true joint venture, if you're raising capital, is to actually change the facts of your scenario, which most of the time doesn't work. Because I'm going to go through some sort of specifics, or what I call my solutions. If you're really trying to make this a joint venture, the challenge that I've seen is that whenever I tell folks, hey, you've got to do this or not do that, then they're like, well, I don't want to do it that way because it's not really what they're trying to accomplish. At the end of the day, most of these quote unquote joint ventures end up being securities offering. I don't think I've said this before, but I really would love it if people stopped looking at joint ventures as kind of a way to raise capital. It's not really what it was designed to do. Joint ventures are meant to be usually two people, right? I mean, I know you can go a little bit further than that, but it's meant to complement each other's skills. Maybe one person is a really good developer or a construction person, and somebody else is a really good asset manager, and so they combine and they do a deal together. Or maybe somebody's a really good, asset manager, but they happen to be in a brand new marketplace, and who knows, Kentucky or something, and somebody else is really an expert in that field, and so they combine forces. Or sometimes you just want to take down a property, like, hey, look, this is a $3 million property. I'd love to do it on my own, but I don't have $1 million, and so I've only got half of it, and so I need a couple of people to kind of help me do it. But I think more and more people are starting to try and use that as a vehicle to raise capital, and that's not what a joint venture is really meant to do. It really is meant to complement different skill sets and not really being the raising of the capital. In fact, that's the first thing I would stop in terms of vernacular terminology. If you're talking about a joint venture or trying to say that something is a joint venture, the first thing I would stop calling everybody involved, I would stop calling them investors, because they're not investors. They are your business partners. They're literally partners. And so, as I mentioned before, the key is that every single person in that joint venture needs to be actively involved in the deal, making significant contributions. I would even go as far as say it's the same definition of when you're doing broker dealer stuff, which is you've got to do substantial duties. It's not sufficient that somebody just show up at meetings or they just sort of have approval for a certain amount of money, some kind of minimum expenditure. You want to show that everybody's actively involved. The first thing to keep in mind is that you want to keep joint ventures relatively small. I don't think you can go over 5. The SEC has already said that if you go up more than 5 people, it's going to be extremely difficult, if not impossible, to show that all 5 of you are actively engaged, that the returns are generated by everyone's efforts. I was talking to somebody the other day where somebody was trying to do a syndication, or I'm sorry, a joint venture with, I think, 15 individuals or something. And there's just no way you're going to be able to show that every single one of those 15 people had sufficient an active role in the deal where the returns were generated by everybody's effort and not the efforts of a few, which is the definition of a security. So keep your joint ventures to 5 or under would be sort of the first litmus test as to whether this is a joint venture or it's a security. The other thing I would make sure is that you have proportionate voting rights, right? So if I put in 20% of the money and I own 20% of the company, let's make sure I've got 20% of the voting rights. And that you use those voting rights for all those key decisions, right? You don't have to have everybody run the day-to-day. You could have somebody, elected as, hey, look, every time you go buy a pencil or something, you don't want to have a meeting with all 3 or 4 or 5 people. You can have somebody run the day-to-day, but you want to make sure that the key decisions are voted on and that everybody has a proportionate vote. It could be a majority vote, but just make sure everybody actually exercises that power. So for example, in real estate, at a minimum, I would say that you want to make sure that everybody gets to vote as to whether to hire or fire the manager of the entity, right? The sort of the asset manager, hire or fire the property manager, buying or selling the property, refinancing the loan. Ideally, everybody's on the loan, although that's not going to be I'm not going to say that's a deal breaker if everybody's not on the loan, but ideally, again, there's 3, 4, 5 people. You want to have all those people on the loan because, again, you're starting a business. Now, sometimes people's credit's not great and all that stuff, and that's fine, but ideally, everybody's going to be on the loan. Don't give yourself or any one person sort of unlimited control. That's going to be sort of your textbook definition of a security. So it's kind of like a sliding scale. The more control you give yourself or a small, a subset of individuals, the more control you give those people, the more it's going to start looking like a securities offering as opposed to a joint venture. So make sure that you don't give anybody any control. And then the other big one, I think, is just make sure that everybody has some, again, we're assuming we're talking real estate, that everybody has some sort of skill that's related to real estate, right? If you've got somebody who's, the quintessential, little old lady who's sort of investing some of their retirement funds, they don't have any experience in real estate, it's going to be very difficult for you to be able to argue that the returns were generated by everybody's efforts if they don't have a particular skill set in real estate. So I think the biggest issue that most people fall under is the control. So you just got to look at your structure and say, are you comfortable with making sure that, hey, even though, everybody has the right to sort of vote you off, if you're designated yourself as a day-to-day manager and people don't like the way that you're, conducting that day-to-day, do they have the ability to vote you off and hire somebody else as manager? Just like anything else, the SEC is always looking at the actual reality of the situation. Just because, you've got on paper, it looks like theoretically you have the right to vote. If you in practice don't have that real authority or influence to make some voting decisions, they're going to look right through that as well. So most of the time, what I see in terms of people trying to call it a joint venture is that they're starting to structure the deals that look very much like a syndication. So again, they'll have a disproportionate amount of ownership in the joint venture. So they might be putting in 10% of the money, but somehow they've got 30 or 40% of the ownership in the joint venture. And again, the question would be, well, why? If everybody's putting in efforts, everybody's rolling up their sleeves, why are you putting in less money and getting a higher percentage of the joint venture? And so anytime you try and change the facts so it truly is going to be a joint venture, it's not something that I'm going to call them a syndicator for lack of a better term. It's not something the syndicator wants to do because they do want to ultimately keep control. They're the ones that really are doing all the work. So just be really, really careful. I'm seeing more and more of these. And to be honest with you, I'm seeing some that's not even close. I mean, to have 15 or 20 people in a deal and try and, call that a joint venture, it's just not going to fly. So anyway, from a paperwork standpoint, I want to touch upon that a little bit. I mean, obviously, one of the reasons people like to do joint ventures is because the compliance is much less, if not non-existent. I mean, when you're doing a joint venture, it's not a securities offering, so I don't have to worry about, accredited or non-accredited, or whether I'm advertising or not advertising. I don't have to put together a PPM or a business plan or anything like that, because it's just 2, 3, 4, 5 individuals getting together and starting a business. So typically what you have is quite simply, we typically create an LLC, and we have a really robust operating agreement. That's really what you have in a joint venture. Now, ideally, all of the roles are very specific as to what everybody's doing. And again, what I'd like to see is making sure that the capital contribution into that joint venture is proportionate to what percentage they're getting. So if I own 30% of the joint venture, I'm going to be expecting that person to be putting in 30% of the deal. Now, that's not an absolute, right? I mean, sometimes somebody might be, because they've got better credit or the higher net worth, they may be guaranteeing the loan, or there may be a recourse, and then because of that, they get a little bit of a different percentage ownership. But generally speaking, the starting point, you should expect to see the ownership percentage meet the amount of money people are contributing. Because again, you're not raising capital. You're just everybody's pooling their resources, and everybody is getting together to do this one particular transaction. So one of the things I would be careful about on joint ventures on the structure as well is that a lot of people like to structure these as tenants in common, which is okay from a joint venture perspective. If it's a true joint venture, the concern there is just an asset protection concern. And so even if you want to hold it, the 3 or 4 of you want to hold something as a tenant in common, just to have some flexibility, maybe on the exit or something, you still want to have that ownership, your specific ownership in that LLC. But make sure you're actively involved. I think one of the easy ways, again, if it's a true joint venture and there's only 3 or 4 of you, the easiest way to show that to me is it's just if all the members are the managers, right? If you have an LLC that everybody is a member managed LLC, so that everybody has that voting right and has the ability to implement that voting right, then that would be sort of the quote unquote safe way to structure it, because by definition, if everybody is managing proportionally, then you're going to have a joint venture as opposed to securities offering. So anyway, I wanted to ask, please put some questions in the chat. I wanted to get kind of sort of specific on this. And so let's get some questions down there specifically on the joint venture. And then of course, I'll be happy to answer any other questions about anything else, but let's make sure we get some joint venture questions here. I think the first one may or may not. Tim, that doesn't look like a joint venture question. I'll get to that one in a second here. Thank you, Chris. Susan, can the JV partners have uneven capital contributions and uneven asset management responsibilities? I would caution against that if there's a legitimate reason for it. I mean, there's no law that says you absolutely have to match it, but what you don't want to be seeing is having disproportionate ownership. I'm sorry, let me just backtrack here. Let me reread the question again. Can the JV partners have uneven capital contributions and uneven asset management responsibilities? Yes, I'm sorry. I was trying to mix and match there. There's nothing that says that, let's just say there's 3 of you. There's 3 joint venture partners. There's nothing that says that everybody has to be a third, right? Somebody may be doing most of the work and putting in, 40, maybe it's a 40-40-20, right? Or 45-45-10, because maybe one of the persons in there, whatever their specific skill is, maybe they're really, they know the marketplace really well, but they've got a full-time job and they don't have that much time to contribute time-wise and energy-wise and work-wise. That's fine. What you want to have, though, is proportionality. I guess that's more important. Everything doesn't have to be equal, but it has to be proportionate. Again, if I'm going to be working 40% of the time and I'm going to own 40% of the company, then I should see a 40% capital contribution. Everybody doesn't have to be the same, but I want to see proportionate representation from the amount of capital that's being put into the joint venture. Again, if there's some extenuating circumstances, as I mentioned before, maybe of the 3 people, one person has really good credit and there's no way the other 2 would be eligible for a loan or something. And so, one person is personally guaranteeing it or something, that's kind of a value add. I could see a little bit of a different ownership percentage there, but the key is that you're not wanting to change the ownership percentage by the amount of work being done. That's probably the most critical one, because then that's what you're really getting into trouble with, because like, well, why are you doing most of the work? Everybody should be doing the work proportionally. If you only got time to work 10% of the JV, great. Then you should be putting in 10% of the money and owning 10%. But it's the proportionality that's really the most important part, not necessarily the dollar amounts having to be equal. Does that make sense? All right. Thanks, Susan. Let's see here. Jeff, member manage LLC versus manager manage LLC. Yeah, so that's an easy way. Again, you're not going to have too many people. Now with 5, do you really want to have 5 people, running the day-to-day every time you've got to lift a finger? But that's clearly the easiest way, especially if it's just 2 or 3 of you. If there's only 2 of you and you're both managing members, or 3 of you and you're all managing members of the LLC, that's going to be the easiest way to prove that everybody's actively involved, because it's almost like by definition, that's what's going on. So thanks, Jeff. Samir, is there a concept of GPs and LPs in a joint venture? No. Or is everyone a member / manager? We'd like to create a structure where one member, us, is the manager, with one co-GP who really gets contingent management rights if we fail to perform. No, Samir, what you just described is a textbook securities offering. So a GP LP structure, by definition, is a GP is somebody who has control, right? They're running the show, and an LP is a limited partner, meaning by definition, their exposure actually is limited. That's why they're called a limited member or limited partners, because their liability is limited to the amount of money they're investing in that investment. In a joint venture, you're not limited to how much you're putting in. Even if I only put in 5%, this is a sort of a general partnership. So if something happens to one of the partners, everybody's going to be on the hook. Again, you're starting a business. So there is no such thing as a concept of GP LP. The minute you have an LP, you have a securities offering. And to be fair, that could be one person, right? Everybody thinks that, that's an easy way around it, but theoretically you can have a 1-person syndication. If that one person is it doesn't have any say and just puts up the capital, that's going to be a 1-person syndication. So Samir, no such thing as a GPLP in a joint venture. Chris, are there any concerns with new JV partners coming in later in the process? For example, let's say JV partners 1, 2, and 3 are in from the beginning and put down hard money. Can JV partners 4, 5, and 6 come in later and get much less equity? Theoretically, yes. I wouldn't go 4, 5, 6. Again, I would cap it at 5. But if you start a joint venture and there's got to be some legitimate reason why you're going to have 2 additional members come in, which there might be. So I'm not saying there isn't, but again, you'd want to see that proportionality. So if the 3 of you are a third, and then 2 more people come in, and let's say whatever my skill set is, maybe I'm coming in because maybe you guys are having a hard time, with the banks and financing, and I've got, that's a skill that I have, and I'm good at negotiating with banks, and I've got good credit and all that stuff. And so you bring me in and I put in 10% of the money and get 10%. You can certainly bring in people at the end of the thing. I do think it becomes harder to justify what exactly those joint venture partners are doing in the deal, because if they come in beforehand, then the stuff that they're doing is a lot of the time is on the acquisition side. It's the due diligence. It's talking to the lawyers. It's talking to the CPAs. It's doing all that sort of pre-work. But yeah, maybe they're just a killer asset manager, and you just realize maybe you got a little bit over your head and you bought this property and you're like, crap, I don't really, I've never done a mobile home park, and so maybe we need to bring somebody in that has that mobile home park experience, because it looks like this it wasn't as easy as we thought or whatever. So hypothetically, you could bring somebody in after the fact. You just got to be super careful to make sure that they're, again, contributing whatever percentage ownership they're going to own, and then making sure that they're actively involved from that point moving forward. Is it safe to say a larger deal rationalizes more JV partners? No. We've done some JV part, and we've done, tens of millions, what was it, like 20 something million. It had two partners in it. So Again, I would cap it at 5. So whatever your thoughts are on how big 5 people can go, but I would definitely not go higher than 5. So I would not agree with saying that the larger deal rationalizes more JV partners. All right. Let's see if anybody else has got a question here. Susan, are there any problems going in the other direction? A syndication that starts acting like a joint venture. I'm thinking of a syndication where the GP is asking LPs to do some more management tasks. It's interesting, Susan. So we usually have the other issue, right? So a lot of the times we have the issue of somebody calls us and says, I want to do a joint venture, and they kind of explain it to us as a joint venture. And I say, well, that looks like a joint venture. I send them over to a joint venture specialist, and then they call me and said, this actually looks like a securities offering. So it's actually, it's a securities offering that we're trying to bring back into the joint venture world. Again, by tweaking facts. Again, it all has to do with the facts. So we can bring it back, but we've got to, again, not just call it a joint venture. We've got to tweak it. But I mean, I think the issue that you're thinking of, Susan, in terms of a syndication where the GP is asking LPs to do some of the management tasks. Just remember, the syndication happens at the point of sale. So you're going to end up having to do all the securities offering on the front end anyway. You're gonna have to do a PPM or follow the securities laws if that's the case. And then, yeah, I could see a restructuring it. I mean, you could certainly start a syndication after you've complied fully with the securities laws. Theoretically, let's just say it's a small syndication with six people or something, and then these limited partners want to have more say, and you then end up restructuring it all. But again, when you restructure everything, you just got to make sure that now there are no GPs that are going to be making all the decisions, that the control is proportionally, and everybody's got the voting rights, and everybody's actually actively involved. So theoretically, I could see it happening, but then you're almost doing it twice, because you still have to comply with all the securities laws and then turn it back into a joint venture. I don't know if I've ever seen somebody do that, but I don't know why you couldn't. Like I said, most of the time what we see is people trying to call it joint venture. We find out it's really a securities offering, and then we're trying to restructure it so that we bring it back sort of over the line if it's on that tight line. If you've got any, let me go back to Tim's question while I wait for other questions here. Tim, you want to just ask you? It's a long type. You want to just come on, unmute yourself, and ask your question, Tim?
Yeah. Excuse me. Can you hear me okay?
Yep. Sounds good.
Yeah, thank you so much. Yeah, a group of us got together. Nobody's got any real experience with real estate. We had an opportunity to throw out an LOI on one particular property. The other people that were concerned about that said, well, you guys don't even have a website. Is this a scam? And on and on and on. So members of the group got together and decided to get a website going. In the name, they call themselves partners. We're not partners. We, by a legal standpoint, we are not an affiliated LLC. We all have our own individual LLCs. So where do we stand on the legality side of that? I understand that if anybody kind of runs south or goes a little bit different direction, the entire group may be held liable for that. And then on the flip side of that, how do we properly split any of the revenue that will potentially come along?
And so your group is the buyer, I presume, and the seller was concerned that you guys didn't have any experience and didn't have a website, or didn't look like they were trying to figure out if you guys were legit, or is it the other way around?
No, in that case, you're correct.
Yeah, so it brings up a great point that you always, and this is not just on this particular topic, by the way, so you always want to be careful whenever you're affiliating with other people about falling into this trap of being considered a partner. A general partnership, for example, doesn't have to have any formal entity structure in order to be considered a partnership. So by your acts and the way you present yourself to the marketplace, you can be considered and held as general partners, even if you don't have some sort of an affiliated entity. And so you want to be super careful about that, and calling other people your partners, as you mentioned in the website. That's step one for a court to consider you guys partners. If you guys are calling yourselves partners, it's going to be difficult for you to start. Not impossible, but it just makes it more challenging for you to suddenly say, well, we're actually not general partners. So the easy way around that is simply to incorporate or create some kind of an entity. And in real estate, we always or not always, generally it's an LLC, sometimes an LP. So that's the way you get around that is you create that LLC. You guys should have an LLC. I mean, if you guys are all getting together to buy a piece of property and you're sending out LOIs, then you should create some kind of an entity that you you operate under. That will protect you guys, in terms of the LLC. Now, if it's a joint venture, then I guess mentioned everybody's going to be responsible for how many people in your group?
It's funny. It kind of seems to be growing. It started out with 6, and I think there are about 9 or 10 of us. And some people are in and out part-time, that sort of thing. I'd have to say that there are probably 7 to 8 that are fully committed and active.
Yeah, I mean, when you have that many people, I mean, somebody's taking the lead. Somebody put together that website, right? So somebody's taken. There's going to be somebody that's kind of the active person, that's kind of the ringleader, or maybe a group of 2 or 3 that are the group leader. So that to me starts to look a lot like a syndication. And what you're really creating is sort of the sponsorship team. Usually the sponsorship team has an LLC. It's not the one that will ultimately own the property, but it's the one that they operate their business under. I'm not going to sit here and lie to you that I haven't seen syndications done by 7 or 8 people, but that's the GP group. Then they go raise capital from passive investors. So it sounds like you got a pretty loosey-goosey arrangement, which always creates potential liability. So I mean, I think what I would recommend is just kind of sitting down and figure out what exactly you guys trying to do. Maybe you bring somebody else. This is great. I thought that's kind of where you were going. Maybe you bring in somebody who's an experienced real estate investor, has some kind of a track record to kind of guide you guys and be your consultant or your mentors or what have you. And then for that service of helping you guys out, you give this person whatever, 5% or 10% of the deal or whatever they want. But you got to be really careful when everyone's, you've got 6 or 7 or 8 or 9 people out there, and there doesn't seem to be too much structure, or people you mentioned people coming in and out and all that. So that to me sounds a little bit concerning. Is your plan to take down real estate just in that group, or are you going to be raising capital from other people?
Yes, to both of those. We started out as more or less a study group, and the next thing it evolved into getting the website and so forth. I am not comfortable with this entire situation. And even with regards to, and they don't know this yet, but I will have some sort of if my name does appear on the website, it'll be as an unaffiliated advisor to keep me away from any of that stuff. And I don't know if I can get away with it, but I'm going to certainly try it. Myself and 2 others seem to be the most active with regards to staying busy with this program. Like this, for example, I'm looking at the groundwork, the footwork, getting everybody together, finding a team out there in the field in whatever area that we're working in. Other people are doing some of the underwriting. Got another person that's actually finding the properties, and then we have the person that pretty much set up the website. A little bit scattered, I agree. All very new to this. In fact, I'm the only one that has any skin in the game, to be honest with you. I do have some properties, and these guys are all renters. So maybe I was put here to help them out and get them on track.
Yeah, maybe. And like I said, I don't. What it's actually one of my pet peeves. I don't think you need 9 people to run a syndication or do any of that stuff. So it sounds like there's usually 2 or 3 people, and great. Somebody's really good at underwriting. Great. Somebody else is really good at the due diligence. Great. But 9 people. There's usually 3 or 4 that are sort of running the show, and those are really your GPs. And maybe a piece of advice would be sort of identify who the 2 or 3 people that are the most serious and start your core group with those 3, and then the others can come in as passive investors if they're willing or wanting to once you've identified a property.
That's perfect.
Yeah.
Thank you so much for your time, and everybody else also for listening in on this thing. I hope it was
no, thanks, Tim. That's great stuff.
To everybody as well. Thank you.
It was. Thank you. Jared, what happens if a member of the JV stops performing their duties? This is always interesting to me, because one of the things, and I'll answer the question, Jared, but it just pops up a couple other things, just another point that I wanted to bring up. You can always remove someone as the manager of an LLC. So, which happens a lot. I mean, if somebody's, we've had situations where some of the sponsors are actually doing some illegal activity, and so you want to remove them immediately from from the management team. And that's just following the procedures of the operating agreement. There's going to be a vote, and you can always vote managers in and out of office pursuant to the terms of the operating agreement. What you cannot do ever is remove people from ownership. Unless there's something already pre-arranged and pre-agreed upon in the operating agreement. Maybe there's a call option, or if, hey, if ABC happens, then, we have the right to buy your shares out or whatever. But again, think of it as you owning Apple stock or Google stock. Just because you're doing something that people don't like, they can't just what's the word? They can't just take those shares away from you. So even if you have either a bad apple, I'm not saying there's a bad apple here, but even if you have a bad apple in one of your joint ventures or LLCs, or somebody's doing something even illegal, you can always remove them from the management side, but you can never remove them from the membership as the owner unless there's something already predetermined in the operating agreement. So if you've got a member of the this is just like doing business with someone, right? If you start a business, again, think of the joint venture as starting a business. If you start a business with two of your buddies or three people, and that business, that the partnership doesn't work out for whatever reason, somebody stops performing the duties or does something that's not aligned with what you guys doing, you guys are in business together. So at that point, you got to figure out, do you dissolve the partnership? Do you end up selling the asset? Do you try and buy somebody else out? You've got to sort of negotiate that on a case-by-case basis as a business. Because that's probably one of the reasons you want to be vetting your business partners, right? You want to be doing, making sure everybody's aligned and making sure on the front end, everything's written out in terms of, hey, here are the duties that everybody's going to be performing. Is everybody okay with that? This is how we're going to be splitting everything. This is this, that, the other. So that's a tough one. If somebody stops performing the duties, you're kind of stuck in a crappy business arrangement. And you can either, fire sell it, or you can just try and negotiate something where you're buying them out, try and figure it out. But you can always remove them from the management, but you're not going to be able to remove them as a joint venture partner without their approval. Michael, is a JV must open an LLC? The partners agree ownership will be vested on one of the partners only. Also, how will this JV going to be taxed and looked at? Is a JV must open? So a JV doesn't have to be an LLC. I would say that's the most prudent way to do it. As I mentioned earlier, if it's real estate, you theoretically could have tenants in common where you have direct title to the property, and then you just have sort of a tenants in common agreement that you can title together. So you don't have to have an LLC. But if the partners agree ownership will be vested with one partner only, look, you can structure stuff however you want, but then the question becomes, how are the other partners, how are they legally getting into contract with each other? Is there a profit sharing agreement? Is there a independent contractor agreement? There's got to be some contractual arrangement with the joint venture partner that's on title. The question I would ask Tyler, Michael, if you want to ask that is, what's the reason for structuring the joint venture where only one partner has the ownership and then the other partners presumably have some, I presume, a profit? What would make sense to me would it be have a profit sharing agreement? Is it because it could be the loan, Michael? Is that the case? Is it because the loan, the lenders aren't going to lend to you guys if these people are on title? If you're still there, Michael. Yeah. So, I'd be a little bit wary about it. So the answer is no, you don't have to have an LLC for the joint venture. It's highly recommended. And if you have an arrangement where only one partner is going to be vested, then presumably you have contractual understandings in terms of profit and share distributions and who's going to do what. And then from a tax perspective, all of the tax benefits is going to flow to the owner. So whoever's vested with title is going to get all the tax benefits. Again, you could theoretically, enter into some profit sharing arrangement where you share some of those tax benefits, but it's all going to be contractual and it's not going to be vested. So not something I would recommend, Michael. I would highly recommend any joint venture at a minimum do have an LLC, even though it's not legally required. Tyler, if the manager whom needs to be removed owns the majority of the LLC, yeah, how can that manager be voted out? At the end of the day, and we have had, I'm not going to name names, but I've had situations where something like that does come up where, hey, look, people commit crimes all the time, right? They commingle funds or they steal money from bank accounts and crap, they end up having the majority vote. And, Now, a lot of times, again, I would always start with the operating agreement. I mean, there's usually some language in the operating agreement which says, if there's something that's, a list of, financial crimes or commingling or stealing or fraud or something, there might be another mechanism. But you always have the option of not the most favorite option, but there's always the option of going to a judge. Right. So you can always go to the judge and say, look, I'm stuck with the terms of the operating agreement. This person is committing fraud, or they're doing this, or we're getting damaged. So we have to partition, or we have to segregate. Obviously, it's not the most inexpensive route, but we have done that. That's sort of your last resort, is to go file something in court and then have a motion and request that the judge, order somebody to do something if they're not doing it on your own. But it's a tough situation when, again, this just goes back to vetting your partners on the front end, right? If you're going to be entering into a business arrangement with them, you want to make sure you do a good job vetting them as much as you can before, make sure you're dating them before you marry them. But that's a tough one, Tyler. I mean, but it happens. It does happen. Michael, Michael with the JV agreement, for nationals that don't want the liability of holding the asset. Well, I mean, again, that's just a business decision. I mean, yeah, I mean, everybody would like to not have the liability of holding the asset, but that's part of the risk reward of the real estate. But yeah, I mean, you're welcome to have, if you want to do that, you're welcome to have contractual arrangements with these other partners. So I would think it's a profit sharing agreement where you say, hey, even though I own it, if you do A, B, C, D, then I agree to share the profits with you, whatever the percentage are, and you can outline all of that in a profit sharing agreement. And then the tax benefits are just going to flow to whoever owns the property. Samir has a suggestion on removing the manager. For removing a majority manager, what we did was to clearly define the criteria under which their management units would be diluted or handed over. Yeah, I mean, it's just a tough situation. I mean, if you've got the foresight to put language in the operating agreement that specifically addresses all these potential issues, where if the manager's doing A, B, C, D, E, then the majority of the non-manager members will have a vote, then that's great. But my experience is most of the time that doesn't happen, and so you really are in a pickle because you're trying to remove the manager, but you need a majority vote, and the manager's got all the voting power, so you may end up having to go to court. Samir, although the waterfall can take change of control into account, as well as the shift of earnings share in the case of cause. That's what we did. Yeah. Again, this is probably another plug for, not for us, but just, whenever you're having here, let me just actually do a plug here for real estate attorneys in general, or really actually a business attorney is really what you want. If you're starting a new syndication group and you're going to have GPs, or you're going to do a joint venture, make sure you just have a really good, either a real estate attorney or sometimes a business attorney to actually review your operating agreement or actually draft the operating agreement. And a really well drafted operating agreement with a business attorney, what's nice about having a business attorney is that they will ask you all these questions. Okay, what happens at this? What happens at that? As opposed to sort of a standard boilerplate, operating agreement that most people start with a business. Again, it's not as cheap as doing the boilerplate, for $500. You might end up spending $2 or $3 grand in putting together a really well drafted operating agreement. That's the benefit of having a business lawyer. They've already done this presumably for many years, so they know where all the potential hiccups are. So they'll send you a questionnaire and ask you what happens if this happens, if that, or what if you want to remove the manager, because there's, the manager has a majority vote. What if everybody else wants to remove you? What are the procedures? Blah, 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 blah. So having a good business attorney. And I think I was thinking of actually doing a live about all the different attorneys, because that's another question we get a lot. Like, what are all the different attorneys that are out there? Because it's like, I was just talking about this with somebody at the event last week where somebody was asking me, a question. And again, it's like, sometimes it's like asking, cardiologists about, a knee replacement where you really need an orthopedic surgeon, right? So sometimes you need an orthopedic doctor, sometimes you need a cardiologist, and sometimes you need an OBGYN. It's the same thing with legal, right? You've got your securities attorneys, you've got real estate attorneys, which are separate from business attorneys, which are different from insurance attorneys. So we may end up doing a live just to kind of help everybody out in understanding what the different types of attorneys are even out there. So, who should be on your team and who you should be going to. So, Samir, that would be really helpful. How to build the right legal team. Yeah, I think that would be helpful. Sometimes people don't even realize, like an insurance attorney, for example, is really critical, and it's worth having your insurance policies reviewed by an insurance attorney, but also consulting with them so they can give you ideas of what type of coverage you may not even thought of, especially if you're like in a property management, for example, it's the one that always comes up. If you've got a property management company, and you don't realize that your employees who are acting on your behalf, you could have liability for those employees. So you want to have some kind of an insurance policy that covers those acts. Having a really good insurance counsel review your policies and give you some counsel, that ounce of prevention is definitely a big deal in the insurance world. All right, guys. Well, I'll let you guys go early today because it's we're coming up on the Christmas season. So anyway, looking forward to next week. And as always, really, really appreciate you guys sticking around. And we'll see you next week for episode 42. Thanks, everyone.